Good evening, everyone. I am Abhinav Shukla, the host for today's session. I, on behalf of the whole team of Just Corpus, welcome you all in today's session on prevention of sexual harassment at workplace. Before we delve into today's discussion, let me provide a brief introduction of Just Corpus and the eminent guest speaker of the day. Just Corpus is a body of legal professionals who have come together to bring various aspects and chains of law under a single umbrella. Just Corpus, an edtech platform set up in 2020, has a wide reach of 600,000 clicks per month on an average basis on our website, www.justcorpus.com. The inspiration was derived from the ever-growing need for law students. Just Corpus has also incorporated an interdisciplinary journal and a multidisciplinary journal as its subsidiaries, named as the Just Corpus Law Journal and the International Journal of Law Research, Education and Social Sciences. Now, turning our attention to today's focal point, we are privileged to have Miss Ashna Siddiqui ma'am as our esteemed guest speaker of the day. We welcome you, ma'am. Ma'am is working as a faculty at School of Law. She is the convener of the Internal Complaint Committee at Birla Global University in Bhubaneswar, Odisha. She has been part of the Birla School of Law since 2019. Previously, ma'am has also worked as a legal associate in SCS Partners, a boutique law firm in Delhi. She did her master's in law from National University, Odisha, and bachelor's in law from KIIT School of Law, and is pursuing her PhD from the West Bengal National University of Juridical Sciences, Kolkata. Her teaching interest is in business law, family law, and jurisprudence. Ma'am has delivered lectures on personal laws to judges at Odisha Judicial Academy. Ma'am has delivered lecture on personal laws to. She has also delivered lectures at MDPs for business professionals. Ma'am has presented several papers in various national and international conferences. She actively participates in mentoring and guiding in legal minds. Without further ado, I would like to hand over the floor to ma'am for her insights on the topic.
Thank you so much, Abhinav, for a beautiful introduction. And it's a pleasure to be back on Just Corpus with an entirely different topic and something that is very, very close to my heart, an awareness that we all should raise. And thank you so much for the invitation. And without further ado, I apologize for the delay from my side. And without further ado, let us delve into a very crucial topic that we have. Abhinav, please let me know if my voice gets a little scratchy or the video is not visible. All right. So before I share my slide, let me first explain the very importance that we have with regard to why we have chosen this topic. Prevention of sexual harassment at workplace is a fairly new legislation that we have. We also need to understand that women have always been working, but they were never sort of considered an employee, and there was no workplace for them which was defined in a particular act. So, of course, their rights have been violated for ages and centuries. It's very recently that we have discovered a legislation to protect them at workplace as well. Because if you look at, say, a century ago, we would not find a lot of women working, right? So it's been only like 70, 75 years after we have had the independent India, and also globally, that women have started working only a couple of decades ago. And which is why the need for prevention of sexual harassment at workplace. We'll have to ensure that when we talk about women, we give them a safe environment to work and show their potential. Without the involvement of 50%, almost 50% of the population, we cannot really reach the goals that we have for our country, and for the world. It is pertinent to mention here that women's contribution in workplace is the only solution primarily, and I speak this on behalf of me specifically, that women's contribution in workplace needs to be celebrated, because it's about time that we ensure that women take up the space that they always deserved but were never given and denied. Right. So having said that, when I talk about workplace and a safe environment for creating safe environment for women at workplace. A lot of people may question that we are allowing you to get educated, we are allowing you to work with us. Now, why would you need a specific, just a second, I'll just pause it. Right. So why would you need a specific legislation now to protect yourself? Is it not enough that we are giving you the opportunity to work and we are giving you the opportunity to stand next to each other and work shoulder to shoulder, right? But it is also very important to understand that the acts of violence and sexual threats, etc., with regard to what women have faced for the longest of time is not and no more restricted to their peripheral area or to their home itself. Now that the women have stepped out to work in offices, we have to ensure that these offices are also a safe area for them to go and work. Otherwise, if we do not create a safe environment for women, there'll be no women who will go out and step out and work, and we will not be contributing to the economy as much as we as women would want to. And of course, when we talk about less contribution from almost say 50% of the population, we will have less development as a country and as a world itself. Right. So this act is extremely pertinent to understand that women have started working, and you would see a lot of women work, but their rights have to be protected. If a woman is not safe in the very four walls of her house, how do we expect that she'd be super safe in the office that she's going to? And even if we would be the most optimist self ourselves, there have been cases of exploitation, demands of sexual favors at workplace, and women have denied that and have lost the opportunity that they would have otherwise got just to be there by doing what they are good at, by showing their potential. But because they have denied certain sexual favors, they have been thrown away, thrown out of the office, demoted, etc. So let me take you through the very act, and then we can discuss the intricacies. I'm open to the question. I'll be able to take it at the end of the presentation. Abhinav, please let me know when my slide is visible, okay? Is it visible, Abhinav?
Yes, ma'am, it is visible.
Thank you. Thank you so much. Right. So when I spoke about the particular act of 2013, before I deal with the intricacies of the act, let us first understand that what happened in the year 1993 and what sort of is the background for this particular act to come into picture and what used to happen before 2013, right? So I'm assuming all of us are law students, and the ones who are also listening to me are law students. There's a landmark case called Vishaka and others versus state of Rajasthan. Now, in this particular case, there was a social worker called Bhavri Devi, and she used to work, and she used to work as in she used to work with respect to make efforts to prevent a child marriage in a particular village in Rajasthan, and she would go from villages to villages and create that awareness for prevention of child marriage. Now, this was not seen very nicely by the men there, some men there, and they gang raped the woman Bhavari Devi, right? This social worker that we're trying to talk about. Now, this particular gang rape of a social activist who's trying to prevent child marriage, what is she essentially doing is she's being the best that she is with respect to doing that she absolutely believes in, that is the idea of prevention of child marriage. And she, in her capacity as a social worker, is at a workplace going from village to village in Rajasthan and explaining men and women that why should we prevent child marriage, what are the repercussions of it, why should we not allow, right? Now this particular woman was not accepted, or her idea of prevention of child marriage was not accepted by these men who gang raped her, right? Now, this particular incident had prompted enough outrage in the country. If you talk about the particular year 1992, and it was only in the year 1993 that we had the guidelines, we'll talk about it. So what happened is a women's right group, Vishaka Women's Right Group, called Vishaka Women's Right Group, they filed a petition and they sought guidelines. They did not seek legislation at first. They sought guidelines to address this particular issue of sexual harassment at workplace. They said, listen, if we are going out, stepping out, this is early 19s. They said, listen, if you're going out and stepping out, what we need to essentially do is at least be safeguarded by the legislation or some guideline, if not a legislation, that we will not be abused, molested, harassed sexually, physically, in any way and every way. We as women have come out of our homes to work, to walk shoulder to shoulder among the men that we have, the colleagues that we have, and at least merely because of the fact that we are women, we should not be suffering. And our idea, our thought should not result into us being raped or gang raped by men who do not believe or subscribe to our ideas, right? Now, the very legal issue in this particular case was there was no legislation. When Vishaka's case happened, there was no legislation specifically dealing with harassment that took place at workplace. Now, this particular case had raised a lot of question about what are the constitutional rights of women who should be given safe environment, which is free from sexual harassment, to work, and what is the duty of the state to protect these rights, because there is absolutely no legislation. Now, in the particular Vishaka's case, the decision of the Supreme Court, which was delivered late, was the fact that they acknowledged that yes, the sexual harassment at workplace does violate fundamental rights of women, namely Article 14, 15, 19, 1G, and 21 of the Constitution of India. We'll discuss these articles briefly a little later in the presentation. Now, in the absence of legislation, the code laid down guidelines, which are known as Vishaka guidelines, to prevent and address sexual harassment at places. Now, these guidelines included the very definition of sexual harassment, that fine, we did not have a legislation. There is a case that has come up in the form of Vishaka's case, Bhavri Devi's case, represented by the group, Vishaka Women's Group. So we call it Vishaka's case. Let us at least give some guidelines for prevention of sexual harassment at workplace. And then when the guidelines were given by the court, they laid down the comprehensive guidelines. It spoke about the definition of sexual harassment, the idea, and this is extremely important, the idea of setting up internal complaint committees at places wherever it is applicable, and conducting inquiries if we receive a complaint. Also, that inquiry has to be time bound. It cannot be left pending for ages and ages, right? Now, what happened here was the impact of the case, the guidelines was this particular Vishaka judgment served as a catalyst for the present act that we have in form of Prevention of Sexual Harassment at Workplace, Prevention, Prohibition and Redressal Act 2013, which we'll call POSH Act. Now, this particular act codified the principles that were laid down in Vishaka judgment and provided a statutory framework for addressing these sexual harassment issues at workplace. Now, this particular case, why am I discussing this particular case? Because it is pertinent to understand the background. Bhavri Devi's case is a landmark case because we realized that we did not have a legislation to protect women. who would face sexual harassment at workplace at that point in time. So when the courts were deciding this particular case, when the court was deciding this particular case, they came up with the guidelines that flew into what we have as POSH Act 2013. But please understand, this was a case of about 1992, 1993. The judgment came in years later, and then it took us almost 2 decades to have POSH Act 2013. Now, if I have to take you to the history of criminal laws, please remember the year 2013 that this act has come up after a woman was gang raped because she was doing the work that she's supposed to do 20 years ago, almost 20 years ago. In 2013, the act came up, and in 2012, Nirbhaya case had happened. That gang rape case had happened. So everything is sort of aligned, and the history, if you look at it, has taken forever, but finally we have POSH Act 2013. Let me now deal with the act straight away, delve into the intricacies. This is the act, and I believe that it's very, very important to read the introductory paragraphs, the preamble of any act that we have or that we are going through. This particular act is to provide protection against sexual harassment of women at workplace and for prevention and redressal of the complaints that we receive with regard to sexual harassment at workplace. It's important to know that sexual harassment, like we mentioned, leads to violation of fundamental rights of a woman to equality under Article 14 and 15. Then we have under Article 21, her right to life and live with dignity gets violated if she faces sexual harassment at workplace. And lastly, the right to practice any profession or to carry on any occupation, trade, business, which includes a right to safe environment free from sexual harassment. This particular act in the very preamble mentions that if a woman has to work in an unsafe environment and probably be subjected to sexual harassment later, it will violate essentially these fundamental rights, 14, 15, 21, 19, 1G also. Now, the very preamble has mentioned CEDAW, which is Convention on the Elimination of All Forms of Discrimination Against Women, which India has ratified in the year 1993 itself. And once you ratify a convention, you have to, as a nation, take necessary steps, make necessary steps to abide by what you have ratified, right? So this particular act came into picture also because we have ratified to CEDAW, which talks about elimination of all forms of discrimination. Of course, when you talk about all forms of discrimination, we are definitely including the discrimination that might take place at the workplace. And how? Because you're being subjected to sexual harassment, because you're being asked for because you're asked for sexual favors, because you're subjected to sexually colored remarks, so on and so forth. So this is the preamble. I have not read it line by line, but I would want you to read it if you can thoroughly, because it's very important to know why has this act come into picture, what will it do, what has been the background like. Now, a lot of us are confused with respect to what amounts to sexual harassment. Some of us may be confused with respect to the fact that, oh, we thought that any particular sexual gesture would only amount to sexual harassment. No, it's a very widely defined term under the act because it's very important, and maybe we'll discuss it during our presentation, that why did we need to define sexual harassment the way it has been defined. Let us go by the definition and the remarks that has been given one by one. It says unwelcome sexually determined behavior, whether directly or by implication. Now, all of us know when you feel a little uncomfortable when somebody is doing something, somebody is saying something, be it directly or be it impliedly, right? Any of that behavior which gives you sort of a hint, a sexual hint, which you can determine and say it's a sexual behavior, which you're not welcoming, which you do not have given consent for, that would amount to sexual harassment. Any unnecessary physical contact and advances that the other person tries to make towards you, that will amount to sexual harassment. Now, this would also include, in the simplest of language, a hug which a male colleague is trying to give a female colleague where she's absolutely not interested in. She does not want that physical contact. It's a boundary. A lot of people may be very okay with hugging their male colleagues, but some of them may not be. That has to be protected. It's as simple as that. It's probably not a big deal for a lot of people who have given consent to it, but whoever has not, any sort of physical contact or advance that you make towards her will amount to sexual harassment. It will also, even if you've not made a physical contact or not, you're determined, your sexual behavior may not be determined, even if you're asking for a sexual favor, demand or a request for sexual favor, that would amount to sexual harassment. Let us say, for example, women who work in offices, corporates, or any other office for that matter, they might be told that if you do not satisfy one of these sexual desires that I have, then you will not be promoted. Then there'll be no increment for you, or you will not be given, maybe the woman who's working has not gotten the letter for the permanence of the job that she is in. So maybe that could be used as a threat to demand or to request. Demand most of the time comes from a person who is senior to you, who has the authority, who has the power. Requests for sexual favors may come from either a senior or a contemporary, any of that sorts. Showing pornography, please understand that even if you want to slightly play it and watch it in a situation where you would want the other person also to watch it along with you, you're trying to directly show porn or indirectly show pornography, any such way, if you're sending it via message, if you're sitting and the person is sitting next to you doing her work at the desk, but you're watching it in such a way that she can also watch and you would want her to watch, and that angle of the camera is such, any of these behaviors would amount to sexual harassment, until and unless the other person has said yes to or given the consent for. Please remember, consent is an absolutely important word here throughout my discussion. When I say, I may or may not repeat it, but consent, if it's been given, then it is not sexual harassment. Anything which is absolutely happening without the consent of the woman, be it a physical contact, be it a sexual favor, be it showing of porn or watching porn, all of it, that will amount to sexual harassment. And of course, any other unwelcome physical, verbal, non-verbal conduct of sexual nature. It may not. A lot of us have assumed that it will always be physical in nature. A sexual harassment, for it to be called a harassment, has to be physical in nature. No. A verbal or non-verbal conduct of sexual nature also would amount to sexual harassment. Like I said, there may not be a physical contact. You could just send something over WhatsApp to someone which violates the boundary that she has kept for herself. That would amount to sexual harassment. Any sexually colored remarks where you are commenting on her body, posterior, any of that for that matter, that would amount to sexual harassment. Now, it's very important to understand sexual harassment, and there are other definitions that we should deal with before we get into who should we go to, what is it about, what would be the punishments like, what is the remedy that we have. Now, please understand, and I would not take a lot of time or spend a lot of time with this slide. Just read it through. It says workplace is a very broad definition with respect to making us understand that it is not just the office that the two people work in. It gets beyond office. It can be wherever you're working at. It can be a party that both the colleagues have gone officially for. It can be anything that these colleagues are in their official professional capacity. So workplace is not just that if your office is in, let's say, New Delhi, in this particular area, any area of New Delhi for that matter, then that is where the workplace would be. If you guys are flying for an official trip to Bombay, then that will not amount to workplace, and you can do whatever you want to do because you will not be covered under POSH. That's a misconception that a lot of people have. If you're going for a business trip to any other particular place, let's say if you're not in office and you're going for an office lunch or dinner in your city itself where your office is, in that situation also the woman is protected because she's still in her professional capacity. She is at work. That will also have the broadened understanding of being at workplace. This is important. Just a second. Any place visited by the employee arising out of or during the course of employment, including transportation by the employer for undertaking such journey. If it happens in a bus, in a plane, wherever you're going, please understand that whenever you are in your official capacity, you're working, that would amount as workplace if somebody violates your right that we discussed or tries to harass you in the way that we have discussed under the definition of sexual harassment. The workplace includes, let's say we talk about anything which is a department, organization, etc., which is established, owned, or substantially financed wholly by funds provided directly, indirectly by appropriate government. So it's not that government, department, organizations, or anything which is owned, controlled substantially or wholly, that is not considered a workplace. That is also considered a workplace, along with any private sector organization, any industry for that matter, be it entertainment industry, health, education, etc. If somebody has gone out, NGOs, anything for that matter would be covered as workplace. If you work in any of these places, that would be called your workplace and you will be protected under the Act. Is not restricted to hospitals, sports, any place that you go, any dwelling place or a house, does not matter. This will include workplace, and the other person will have to be charged under this particular act. Now, what do you mean by an aggrieved woman? Many times you will find out in the particular act, there is a term that we use that's called aggrieved woman. In relation to a workplace, a woman of any age who alleges to have been subjected to any act of sexual harassment by the respondent would be called an aggrieved woman. So if you're a woman who is alleging that you've been subjected to sexual harassment by so-and-so who works in the office, who owns the office, who is a third-party contractor in the office, all of that, in that situation, you will be the aggrieved woman. And in situation where we talk about a dwelling place or house, a woman of any age who is employed in such a dwelling place or house, that would be called a aggrieved woman. So any woman who alleges that I have been subjected to sexual harassment, that would be called an aggrieved woman from the perspective of this act. Now, Section 3(2) talks about prevention, and 3(1) specifically says, clause 1 says, the women should be given safe space and there should be prevention of sexual harassment from workplaces in every possible way. 3(2) lays down that these following circumstances, of course, among other circumstances, may amount to sexual harassment. Any promise made impliedly or explicitly for preferential treatment in her employment. If you're making a promise saying, do this to me, do that for me, asking for any sexual favors, saying or promising that she'll be preferred over others, or she'll be given a treatment which others are not getting, that may amount to sexual harassment. Not just preferential treatment, but detrimental treatment. Like the example I was giving. Yahan pe first wala example was you will be getting promoted. Second, maybe that if you don't do this, I'll demote you. I'll remove you. We will ensure that your salary goes from this to this. There'll be a decrease in salary. Anything of that sort would be covered under detrimental treatment, and that may amount to sexual harassment. If there is an implied or explicit threat about her present or future employment status, like I said, if they say that your nature of job right now is temporary, you would have gotten permanent position 6 months down the line, but we'll ensure that you don't do that. You don't get permanent position. You don't get, your probation period does not get over and we remove you because you are not doing what I've asked you to do. That will also be sexual harassment. Interference with her work or creating an intimidating or offensive or hostile work environment for her. When we talk about creating safe environment for her, it's important to understand people in power or people whose ego has been offended because a woman has said no to them or him. They may interfere with the work that the woman is doing, create a very bad work environment for her, intimidating work environment for her, where she's afraid of asking for something, going to some place in the office itself, where it's offensive, where you're saying bad words to her, where you made it so hostile as to that she's striving to have a conducive work environment, but she's not getting it because nobody's talking to her. You have spread ill rumors about her, or you have, because you are in a powerful position, you have said to your team that please don't speak to her, make her feel that she does not exist, make her feel non-existent, XYZ. Any of this sort will amount to sexual harassment. And humiliating treatment likely to affect her health or safety, where you humiliate her, make her feel unsafe, do not provide for her health, which may affect her psychological health, to be very honest. Any treatment, any humiliation has a very long-lasting effect on how we feel about ourselves and our mental well-being. So any of those treatment that may affect her health, specifically mental health, that also would be covered as under sexual harassment and may amount to sexual harassment. Now, what do we do when all of this happens, right? Who do we go to? Please understand that at an office, if you have more than 10 employees, it is mandatory for your workplace, no matter which organization are you working for, it is mandatory, excuse me, to have an internal complaint committee under Section 4 of the Act that we're talking about, POSH Act 2013. The very criteria that you have to have 10 people is to understand that this ICC will have 4 or 5 people, where 4 or more than 4 people, where they'll take decision, they'll inquire into the complaint that one receives, and then they will give it to the authorities with their recommendations and inquiry report. Now, what ICC does is they look into the allegation, because of course, until it's proven it's an allegation, an inquiry report gets submitted to the authorities of the organization. Now, who all should be in ICC? What is the minimum requirement in ICC of members? The committee should have a minimum of 4 members, and half of them have to be women. So you can have 4 or more members in your ICC if you're an organization which has 10 plus employees. But remember that no matter how many members do you have in ICC, half of them have to be women. So if you have like about 4 members, 2 of them have to be women. And the one who would be the chairperson or the presiding officer of the ICC has to be a senior level woman worker. So the one who will preside over this particular committee, internal complaint committee, would be a woman. And along with having a woman from your own organization, a senior level woman worker, you should also have one person who is an external member. So basically an expert who may be from an NGO who work on women's right or any other related area. So what are we trying to understand here is that ICC, there's a requirement. You have to have 4 members. or more than that, and half of them have to be women. That preceding officer has to be a woman who works in the company at a senior level, or the organization or the university at a senior level. And the committee should also not just have people from the organization, but an external member, say an expert in the area of women's right, maybe from an NGO who work for the women rights, right? What does this do? Essentially, ICC, a combination of people from the organization along with an external, helps us keep the balance and gets the transparency in the system. Like for companies, we have independent directors. Similarly, for our ICC, we have to have an external member who would bring in that freshness of an unbiased, transparent inquiry that ICC is supposed to conduct. If you don't have 10 or more employees, if your organization does not have 10 or more employees, let's say you are a partnership firm, let's say you are a company which does not have 10 persons, 10 people, then you can go to local complaints committee. Like ICC is for 10 or more people, you have LCC. LCC helps us address complaints of sexual harassment at grassroots level. It is important to mention that not just people who work in huge organizations or not just women who work in these huge organizations are protected. With the help of LCC, we are also protecting women who may work for a smaller unit, who may work for a smaller organization, which may not be registered per se, and there they will not be able to have an ICC. For them, we have LCC. It oversees the entire investigation process. The DC, you can go to your nearby DC office. They will help you understand and file a complaint. The DC office has it. Most of the times, it's the deputy collector. They will ensure that there is an LCC at the level, district level, which will have members like an eminent woman as chairperson, one member from the very block which the district is in, two from NGOs, wherein one must be a woman and the other must have law background. And then there should be social welfare officer. District officer here will designate one nodal officer for each block. And these nodal officers will be the point of contact. They will receive complaint and forward it to the local complaint committee within 7 days. An aggrieved woman, the definition that we have understood, that aggrieved woman should go to LCC in case of less than 10 employee or complaints against the employer itself. Let's say I have just been employed by 2 or 3 people. They're paying me, everything is going well, but one of them has asked for a sexual favor, which I do not want to, of course, and I'm not giving consent to, but I have a fear that they will just remove me from the job. But I'm doing extremely well at my job. Why should I be removed, right? So I go to LCC and I write a complaint, give a complaint to the nodal officer. He forwards it to the LCC and they will start the inquiry process, correct? Now, what is the process of writing complaint, be it to ICC and LCC? And with this, like in another 2-3 slides, I'll finish and then we'll be open to questions. A written complaint has to be given to ICC and LCC, given your condition, whether you fall on 10 plus employees or less than 10 employees. And it has to be done within 90 days of the incident. And if the incidents are recurring in nature, meaning it has been happening for a long time, it's 90 days from the last day of any of such incident that must have happened, or any sexually colored remarks, sexual favor, anything of that sort that would have happened. So from the last day of that to 90 days. Now, please understand, many a times you would find that a lot of matters are settled. When I say settled, they undergo conciliation. And aggrieved woman says that, fine, I'll ask him to write an undertaking and behave properly with me from next time onwards. Meaning, let's say, for example, there could be a case where a person has winged at the woman in a very different way, trying to drop hints or something. In that situation, the woman may not go to ICC, LCC and ask for a solid, thorough inquiry. They may say that, fine, I have come to ICC, but I would want to undergo conciliation. So let him write an undertaking and let him get done out with it. Also, he should ensure that he does not behave like that ever again to me. Simple, sorted, nobody loses their job for matters which are at the very virtue of the aggrieved woman and she says, "Ki, I am okay with it." Her request has to be there for conciliation. And please, when we say conciliation, it is not that we pay a woman some amount and we ask her to withdraw the complaint or conciliate and say, fine, we have come to a common point. We do not want the matter to go ahead. I understand he was at fault. He is apologetic about it. There should not be any monetary settlement. Please remember this. What happens then is ICC or LCC, whichever the case may be, will forward the copy of settlement to the employer, district officer in case of LCC, and one of the copy would go to aggrieved woman and respondent saying that these people have settled the matter, they have undergone conciliation, and the woman is ready to conciliate, and this is the copy of the final settlement. When the settlement has not been carried out or it has not come to fruition, then ICC or LCC will initiate inquiry. अगर कोई settlement नहीं हुआ है तब inquiry की तरफ हम जाएंगे, right? And in situation when there is grave sexual offense with regard to the sexual harassment that we're talking about, we do not want any settlement. These are minor things that we're talking about where settlement may happen at the instance if the woman agrees, of course, aggrieved woman agrees. Now, there is a timeline because we don't want pendency. We don't want the woman to suffer. We want the safety of the aggrieved woman. So, ICC inquiry has to be completed within 90 days. If even after then the case sort of exists, then they may forward it to police for registering under 509 of IPC, the new BNS. Contemporary section would be there within 7 days of inquiry. Under Section 13, the inquiry report to be given within 10 days of completion of inquiry to both the employer or the district officer, whatever the case is, ICC or LCC. The employer or district officer shall act upon the recommendation. Since ICC or local complaint committee, these are not authorized to give punishments. They can just give recommendation via their inquiry report. Employer will act on the inquiry report. District officer will act on the inquiry report of ICC and LCC respectively within 60 days of the receipt and take whatever decision that they have been suggested, recommended by these ICC, LCC. Meaning, if you file a case, ICC gets done with their inquiry within 90 days, they write a report, send it to the employer saying that we have found this particular person guilty of sexual harassment. He, as per the gravity of the incident, he may be removed, terminated from the job, or he may be asked to sign an undertaking, or he may be asked to not be paid for next 1 year for his service in the office, etc. All of these recommendations may be provided to the employer and the employer will have to act upon it. If still there is an aggrieved person who is not satisfied with the decision, they will file an appeal within 90 days. If it's an ICC, it will go to the higher authorities. Now, please understand what are the penal consequences. Indeed, sexual harassment is a punishable offense. ICC will not give punishment. The court of law will, right? ICC will make recommendations to the employer or the district officer in case of LCC, and they will then take it forward. If you are inappropriately touching a woman, and of course, if it be it at workplace or not, it can be a 1 to 5 years jail and fine under the Amendment Act of 2013. If you are distributing, capturing, observing images of a woman without her knowledge, then we have IT Act and the specific punishment of 1 to 7 years is defined there. If you're using words, gestures to outrage a woman's modesty, then about around 3 years jail and fine under the Criminal Amendment Act of 2013 is there, right? Now, we have discussed so much about what happens to a woman. We talk about an aggrieved woman. We talk about the fact that the woman should be protected. There should be a free and safe environment. We have taken care of what is the process. Now we know that if a woman is working in an organization, if she faces what we can call sexual harassment, as per the definition that we have read, then she can go to internal complaint committee. file a complaint, they have to do the inquiry for her within 90 days, suggest, and the employer has to take action after receiving the inquiry report and within 60 days of so and so. Perfect. But there are two things that I would also like to discuss when I'm just about to conclude. A lot of women know that the ICC may not give the findings of the inquiry report as to what she has gone through, and there may be biased reporting in the inquiry report. B, a lot of men who undergo sexual harassment at workplace are absolutely unaware whether or not they'll be covered under this act. So when we talk about POSH Act 2013 and the gender neutrality of it, it is a very gender specific act, unfortunately. It does not essentially give us the term an aggrieved man. It does not talk about men in the legislation. That is a limitation of the act, if you ask me. Having said so much about the violation of the rights for women, I think it's about time that we have the gender neutral aspect added to what the legislation we have in our hand in 2013, because there are women who are breaking the glass ceiling and at the topmost position, and they may definitely demand for any sexual favor, pass on any sexually colored remark, harass them sexually, physically, try and make advances, whatever we have discussed in the definition of sexual harassment, a man can also be subjected to that. So if you ask me, is the act of 2013, like the POSH Act, gender neutral? Sadly, it's a very gender specific act. But that does not stop the organizations to adopt inclusive policies, meaning even if the act does not say so, legislation does not say so, we definitely have given the organizations the authority to make their ICC take the complaints from male counterparts also if they have faced allegations of sexual harassment from some woman. So, right, the act is gender specific, but the organizations are encouraged to adopt inclusive policies, meaning also include men who may be the victims of sexual harassment at workplace, right? Now, lastly, because a lot of you are college students, students of law, very important that there is a UGC regulation of 2015, University Grants Commission regulation of 2015, which protects the university, the people in the university, the stakeholders in the university. It says, please know that under UGC regulation, the regulation with respect to prevention, prohibition, and redressal of sexual harassment cases in a university, in higher educational institutions, are gender neutral, meaning that all of you are equally protected from sexual harassment within the university setting. So if your university, I'm sure all of your universities have ICC, Internal Complaint Committee. Please, if you ever feel there is anything that is not making you comfortable, if you think that anybody is trying to misuse their position, your batchmates, your seniors, your faculties, anybody, whosoever your junior, please feel free to reach out to your ICC irrespective of your gender. I wanted to show this slide because I know that most of the viewers are from university, and no male students should feel that they are not protected and their rights are not protected. So yes, please feel free, and UGC regulation is there, which brings in the gender neutral aspect in the universities, and male and female, everybody is allowed to go ahead and file complaint to ICC if they face any sexual harassment. Thank you so much. It's indeed an elaborate session, but I've tried to keep it short, not throw a lot of legislative provisions or mention sections and sort of not interest you. It can be a topic which I might explain with a smile, but it worries my heart when I talk about sexual harassment cases and sexual harassment at workplace cases, because not very recently, but we have been seeing cases of sexual harassment at workplace, at corporate law firms, at litigation firms, at companies, at universities. People in the highest position have tried to misuse their power, regardless of their gender, and violate the basic rights that we have entrusted with. If we do not have a safe environment, we will never be able to have a developed country, because we need all our population to work safely. Thank you so much. It was a pleasure. Abhinav, any question? Please go ahead.
Thank you so much, ma'am, for sharing your valuable insights. I do have questions with you. Ma'am, the first question is, could you please provide some practical and realistic advice on how to prevent any kind of harassment from professors at university?
Right. So, like I said, when you define sexual harassment, you definitely take care of people in a powerful position asking for any sexual favors or making a sexually colored remark. It could be for any gender, to be very honest. A practical way to approach this would be, I think, to not let them have access to you, to clearly say no and ensure that they know that you're so powerful that you might go ahead and complain to the internal complaint cell. And considering the times that we live in, everybody should be powerful enough. Everybody at least should feel powerful enough, because we live in the age of social media, which have its own pros and cons. But if you know that you're true to yourself and you have said no clearly to the professor, and if he's still not taking a step back, go ahead, write it to the internal complaint cell. If the internal complaint cell does not do anything, do not mind writing letters to authorities, to judges. Everybody is there out there for you. Do not let them take advantage because they're in a powerful position. The practical exercise here would be, first, say a solid no. I know as a student, we feel very underconfident. We think that we'll probably flunk in the paper because they have marks in hand. We will not get enough exposure. We might not get enough recommendation. They may not allow us to participate in different competitions, right? Say a solid no. If they do not agree, if they do not listen to you, tell them that you will write a complaint with ICC. You know what ICC is. It's very important to tell your professors that you know what ICC is. A lot of people don't know what ICC is. So it's important to tell them that. In case nobody is listening to you in college, your complaint is not being registered. We live in the time of social media, and I have no hesitation in saying that. Take that matter out. I know, to protect your individuality, to not let your name come out, it's a big deal. But feel free, as law students, as student of any university, any course, we'll have to believe ourselves and know that this person cannot let us or make us feel that inferior, right? So that's one of the things that I would suggest. A solid no has to be there, regardless of the gender. And then when you tell somebody that you know what the repercussions could be for them, they might lose their job, they definitely take a step back. That has to be conveyed.
Thank you, ma'am. I mean, the next question is, how can remote work environments address and prevent sexual harassment given the unique challenge posed by virtual interactions, the remote work environments?
Right,
So,
right. If you look into the definition of sexual harassment that I was talking about, it says verbal conduct or non-verbal conduct. So it may not be, you may not be physically present. It may be a virtual setting where you're working for somebody, work from home, or you are in a setup where you're not meeting that person. But if they have said any sexually colored remark, passed a comment, compliment, tried to ask for favors, asked you to do something on the phone, send you some pictures, any of that also would amount to sexual harassment. And you can go ahead, and if you work in an organization which has 10 plus people, they will definitely have an ICC. Please go ahead and write. You know what? A lot of people have this misunderstanding about the fact that you have to be physically present or be in the workplace offline mode, and you cannot work from home, etc., for you to go ahead and file a sexual harassment complaint. Absolutely not. Your virtual mode does not have anything to do with violation of your rights. If your right has been violated, feel free and write it to the ICC.
Thank you, ma'am. The next question was about the POSH Act being gender neutral or gender based, which you have specifically elaborated a lot. So I will move on to the next question that I have. That how would you motivate or approach someone who is going through same but afraid to speak up and come out on sexual harassment faced with her or his seniors or as well? Like, what if you feel sexual harassment by same gender? There are two questions in it. Like, how do you motivate? And the second is about the facing sexual harassment from the same gender.
Correct. Okay. How do you motivate? Listen, if somebody is going through a time like that where they can't really speak to others about it, you have to make them feel seen and heard. You don't have to, what's an absolute no-no is don't question them. It's not very frequent that somebody will make up a story of sexual harassment. It's the fact that they're going through it. So make them feel seen and heard. Tell them that you trust them. Tell them that you believe in them and you cannot even think of what they're going through. Give them that comfort. And once you're done doing that, please tell them that it's important that they write a complaint so that they feel relieved that they did something for the wrong that was being done to them. B, it does not happen with anyone else. Because today the person who is seeking comfort, asking comfort for what they're going through, if that person does not speak up, it might happen to the other person who's trying to comfort this person without knowing what is happening exactly, right? So a person in power, they are always looking out for people they suppress, people who they can absolutely be, who they can suppress and make feel inferior. So they'll have to speak for themselves in order to protect their rights and also for others who may be harmed if they are not called out, if the perpetrators are not called out. Let me put it that way. And the gender aspect, all right, I have told you it's a very gender specific legislation. It talks about an aggrieved woman. It talks about a man specifically harassing. Of course, there have been cases, and now we have become a society where we are talking about queer rights, etc. We also need to understand that the organization has the power to make their policies, their rules in such a way that if the person who's facing sexual harassment from the same sex also, they will also be punished and there can be a complaint filed for them also under ICC. A lot of ICC has started doing that, meaning a lot of organizations have started doing that. If you look into the entertainment sector, a few years back, there was a female comedian alleging a female comedian about sexual harassment, right? So there have been inquiries in the same case as well, in the said case as well. Now the times have changed. Anybody in power, regardless of their sex, can try to make use of the power that they have and suppress the person, harass the person sexually, physically, in any which way. And the rights of the harassed is protected.
Ma'am, the next question that I have is how do we fight with false accusations? Like,
very important. Having talked about gender neutral and also the fact that it can happen it can be done by the same sex itself. It's also important to understand that a lot of women, because we're talking about a very women-specific legislation, accuse their seniors, their contemporaries, their counterparts falsely to get their things sorted and done. Maybe after a fight, a woman would try and scare the other person and be like, I'll file a complaint, sexual harassment complaint against you because you're not listening to me, you're not saying yes to me, you're not. A lot of times what happens is, let's say two employees of a particular company are dating each other and the other person and the man has said that, no, I don't want to get married to you, right, etc. So this particular woman might just go ahead and file a case of sexual harassment for something which was an absolutely consensual act, right? What happens is there have been sadly, a tremendous increase in false cases. But in order to deal with it, if somebody is a victim of these false cases, let's say a man has been trapped into a false sexual harassment case, the man has to hold his ground, come up with the evidences that he has, show that the availability of whatever evidences that the other person is saying is not true. And truth be told, everybody has started realizing that there can be false cases. So they are being dealt with in the similar manner. It's not that the moment a woman writes a sexual harassment complaint, there is no inquiry and the man is kicked out of the company, etc. No, everybody has realized that there are false accusations also. You will find out a lot of registrars and vice chancellor, etc. of university, any university, they get accused of sexual harassment by female employees sometimes, because these female employees are trying to get the promotion, but they're saying that you're not eligible to get the promotion because you lack this qualification, that qualification, etc. And to bring in a bad name to these authorities, registrar, vice chancellor, etc., female employees, female teachers, etc., might go ahead and file a false complaint. But like I said, truth be told, everybody has started understanding that there can be false cases also, that the inquiry has to be absolutely impartial, unbiased, transparent for both men and women, and let the truth come out accordingly. So one has to not get afraid merely because of sexual harassment case has been filed against them. If they are true, if they're honest, it will come out. They'll have to ensure that the proper evidences are submitted.
Thank you so much, ma'am. I think we are done with the question and answer round. It was incredible listening you. Uh, like in closing, we extend our heartfelt gratitude to you, ma'am, for accepting our invitation and delivering such an informative session. We trust that the audience found it both interesting and knowledgeable. Thank you once again, ma'am, and we eagerly anticipate the opportunity to host you again. Thank you so much, ma'am.
Thank you so much, Abhinav. And I'm extremely, once again, apologetic about making you guys wait. Thank you so much, Ayush, for the invitation. And as I always say, looking forward to more opportunities with Just Corpus. It's indeed a pleasure for me to be a part and to share my thoughts. Please forgive me if I have made any mistake, but I've tried to bring in the best with respect to what my ability to understand these legislations and perspectives are. Thank you so much.
Thank you, ma'am.